Hello everyone, good day. I'm Francesca and in this video, I'm going to discuss about first, by civil interdiction of any partner, which is one of the causes of dissolution provided under Article 1830. Second, who can sue for judicial dissolution, and last is on application by or for a partner, which is under Article 1831. But let us first have a short recap since these were relevant to the topics I'll be discussing and for better understanding. So, as we all know, there are two kinds of dissolution, the extrajudicial dissolution and judicial dissolution. Extrajudicial dissolutions, these are numbers 1 to 7 of Article 1830, causes of dissolution, while judicial dissolution refers to number 8 of Article 1830 in relation to Article 1831 of the New Civil Code. When we talk about extrajudicial dissolution, these are enumeration provided for by law that the grounds are not legal cause for dissolution, but these grounds provided will also result to automatic dissolution of the partnership. But when we say it needs judicial decree, the cause of dissolution needs to be confirmed or verified by the court. So meaning, in judicial dissolution, there is a question of fact. So, Article 1830 provided causes for dissolution. Number 1 to 6 provided in this article were already reported, so I'm not going to explain it anymore. So now let's proceed to number 7, which is the causes of dissolution by civil interdiction of any partner. So what is civil interdiction? Civil interdiction deprives the offender during the time of his sentence of the right to manage his property and dispose of such property by any act or any conveyance inter vivos. This means that one who has no capacity to manage his own property should not be allowed to manage partnership property. Next, dissolution caused by the decree of court. Decree of court, this may be ordered up after hearing upon application. So, meaning someone has to apply. But let us first know who can sue for judicial dissolution or who can apply. So, sabi dito, there are two who can sue for judicial dissolution. First is the partner and second is the purchaser of the partner's interest in the partnership. But I will be reporting only about a partner or an application by or for a partner. Article 1831 provided that when a partner files an application, the court may order dissolution in the following cases or grounds. First is whenever a partner has been declared insane in any judicial proceeding or is shown to be of unsound mind. So kapag insanity yung grounds, the insanity has to be previously declared judicially, or if not, the insanity must be duly proven and such insanity must materially affect the capacity of a partner to perform his contractual duties. This is because insanity will make a person incapacitated to enter into a contract like a contract of partnership. And also, it will affect the capacity of a partner to perform his contractual duties. Hindi naman pwedeng sabihin mo lang na yung partner mo is baliw or nasisiraan ng or may something sa pag-iisip without proving it. So, kapag insanity yung grounds, it must be proven in court. Second is whenever a partner becomes in any other way incapable of performing his part of the partnership contract. So, for example, si A, si B, and si C, they formed a partnership, the ABC partnership, to engage in the private practice of law. However, subsequently, C applied and was appointed as a government legal officer, and si C, he was not given the authority by their head of office to engage in the practice of law. So, hindi siya pinayagan. Ibig sabihin, in this case, C will be incapable of performing his part of the partnership contract. The court shall also decree a dissolution whenever a partner has been guilty of such conduct as tend to affect prejudicially the carrying on of the business. For example, conducts na like laziness, indecent behavior, theft, dishonesty, sabotage, offensive behavior. So, this conduct, pwede itong maka-apekto sa carrying on of the business or dun sa operation of the business Next is whenever a partner willfully or persistently commits a breach of the partnership agreement or otherwise so conducts himself in matters relating to the partnership business that it is not reasonably practicable to carry on the business in the partnership with him. So, for example, A, B, and C, they formed ABC partnership. And si C naging lasenggo or lasinggero. Lagi siyang umiinom which causes his habitual tardiness and absences from their office despite warnings from A and B. So, itong si C, despite warnings from A and B, tuloy pa rin siyang nag-engage dun sa gawain niya na nakakaapekto na sa carrying on of the business or operation of the business. Next is whenever the business of the partnership can only be carried on at loss. As we all know, the purpose of the partnership is to gain profit. Also, take note that the intention and essence of every business partnership is to divide the profits among themselves. So, if the business of the partnership can only be carried on at loss, the purpose of the partnership is defeated, or it is materially affected, or it is obstructed. And lastly, other circumstances which render a dissolution equitable. So this is a catch-all provision for other grounds of judicial dissolution na hindi nabanggit kanina as long as this can be proven in court. Some examples of these are abandonment of the business, fraud in management, refusal without just cause to render an accounting of partnership affairs, and the like. So, there can be a judicial dissolution if the continuation of the partnership or of the business of the partnership has become inequitable. And this is the end of my report. Thank you for listening.